Hello again. Good afternoon. I am Dan Wu. You're listening to Unquestionable here on KZSE Santa Cruz. Thank you so much to Do Make Say Think for the background music there. For this week's episode, I'm very excited to hear about labor relations in the 21st century from Uber suing attorney Shannon Liss-Riordan, who does much, much more than that. However, I am framing it in that way because of all of the things going on with specifically Uber right now. And I don't want to get too much ahead of myself on it. But basically, if you don't know, Uber's been around for about 10 years now. It purported to be able to revolutionize the cab industry by letting you get a cab through your phone. I'm pretty sure that was already done before then. But it is now on the stock market as a publicly traded stock as of the IPO going public last week, at the end of the week. A lot going on with strikes by the drivers, all kinds of things. Shannon Liss-Riordan is an attorney at the center of all of that. And I will stop there for the moment. And how's it going, Shannon?
Pretty good. Yes, there is a lot going on these days.
Absolutely. And I want to start back at the beginning for you. First off, I did read that you and your partner at your law firm have close to 6 decades of experience. How much of that would be years of experience you have practicing law, and maybe specifically with labor rights issues?
I have been practicing law for 20 years, and the entire time I have been representing workers. I've been representing employees in wage cases against major employers around the country. We also represent labor unions. But that's been my whole career, is fighting for the rights of working people.
Focusing on Uber, and we will get broader about this because I don't want to just demonize, highlight, and pick apart one company. I don't think that'd be fair to them, but I don't think that'd be fair to workers either. But just for the moment, as a starting point, how do you rate the current situation with the strike last week and then the IPO coming on the heels of the $20 million settlement of a case that you and your law firm were the lead counsel for against Uber as far as labor rights violations? There was that $20 million settlement to workers for, I believe, unpaid costs of doing business, and then the IPO, which didn't really work out in Uber's favor, and you still have future cases pending against Uber, correct?
I have cases pending against pretty much all of the gig economy companies, and Uber was the one that made this the most popular in the public's imagination. It's obviously been the biggest. It's been the most talked about. But there is a whole industry out there that is trying to convince the world that somehow the rules of the workplace have changed, and just because they dispatch their work through an app on a phone, they don't need to pay attention to any kind of workplace rules anymore. And that is what I've been fighting. That's been the focus of my legal work for the last, I'd say, 6 years. I've been fighting companies who misclassify workers as independent contractors for a good 15 years of my 20-year legal career. But the gig economy has been taking up a lot of my time for the last 5 or 6 years. And like you mentioned, the main issue we have, there's a whole host of workplace rights that workers miss out on when companies misclassify their workers as independent contractors. There's just basic wage protections. There's rights to have the employer pay employer share payroll taxes. There's workers' comp if you get injured in the workplace. There's unemployment if you lose your job. There's the right to band together with your coworkers and form a union. So all of these companies are really calling their workplace independent contractors, so they don't have to worry about any of those rules or regulations. We've been fighting it for a long time. We did reach the settlement for a group of Uber drivers in court who aren't bound by an arbitration clause, which is what many companies have used to try to prevent big systemic class action cases from going forward in courts. Mm-hmm. And last week, Uber drivers took to the streets. Like I said, we fight them in court, we fight them in arbitration. Sometimes you just have to take it to the streets. And I thought the demonstration last week, I was out there with them in San Francisco. I thought the demonstration was a great showing of their strength coming together and raising awareness about the issues in the workplace that this company and other companies are perpetuating through this so-called new model of work.
Now, I want to skip back. Now that we've covered a bit of, you're right, a zillion issues. I could talk to you about this forever. I want to take you back to the beginning, an article I found, kind of a bio on you, to your story of first encountering Uber while visiting a friend in San Francisco. What was your first reaction?
So a friend of mine, he pulled out his phone and he was saying to me and my husband, "Oh, have you seen this new app? This is really cool. Look at this. You just press a button and a car shows up on your phone, and you can click the button and a car can pick you up and take you wherever you want to go. Isn't that amazing?" And I looked at that and I thought, wow, that is pretty interesting. That is pretty cool. But I was immediately thinking about, well, who's driving that car? How are they getting paid, and what is the whole setup here? So that was my very first introduction to this company, to this app, to this whole world of the gig economy. You might say that was the first question that ran through my head.
And it says in the article that your friend immediately saw the look on your face and said, "Oh my God, don't do it. You're going to put them out of business." Now, that's not necessarily your goal, I wouldn't think, with industry, but why did they have that reaction to the look on your face?
Because this friend of mine knows about what I've been doing for the last 20 years, and he knows that I've been fighting big companies who've been taking advantage of workers. He knows that I put a few out of business. That's what his concern was. And no, it's not my goal to put companies out of business. My goal is to get companies to comply with the law and to enforce workers' rights. So my view is that companies, if you're going to do business, if you're going to have employees, you should abide by the law. Otherwise, you shouldn't be in business. That should just be a basic principle. So what I believe in doing, and what we've been trying very hard to do through enforcing these workplace rights, is create a level playing field. Not just for the workers, but for all the businesses out there that may be trying to do it right, maybe trying to comply with the law, and they shouldn't be getting undercut by those companies who are willing to skirt the law and avoid their obligations, because then we just have a race to the bottom with companies not having any responsibilities, and workers are the ones who really lose out. And workers, complying competitors, and ultimately our whole society, our government, our state and federal governments lose out when employers don't pay their fair share. It's really corporate welfare is how I see it. If we let companies get away with not complying with their obligations as employers, we're just giving it away to companies so they can get fabulously rich, while the working people who are driving their business are struggling to survive.
Now, on that same meeting with that friend, on this note, what did he mean when it changed? He said it changed his life. The Uber app had changed his life because, like I mentioned before, cabs were called by cell phones before Uber existed, but all of a sudden it was cheaper and people were using their private car. And did your friend or other people you've talked to ever wonder where those other costs went? And with workers you've talked to, what's the psychology with them? What's the psychology that leads people to think that the costs of doing business just disappeared and made it cheaper?
Yeah, well, that's a big problem, is that these companies have been so great at marketing themselves and selling their business to the public as this really cheap, convenient alternative. And, of course, it's made everyone's life easier. It makes consumers' lives easier if you can get products and services for cheaper, and it's really easy to access them because you just have to press a button on your phone. But what I want more people to be thinking about, and what the Uber drivers strike last week, for instance, highlighted to more people, is that there is a cost to that. There are real people on the other side. There are people who are doing this work to try to pay their bills, to support themselves, to pay their rent, to feed their families. Some of them are students trying to pay tuition. Some of them, it is an extra job to make a few more bucks, but shouldn't they have basic employment protections for that time that they're spending doing that? So I think we need to raise awareness that people need to realize that if it's costing less to access these services, there is a cost to that. That means the people providing the services are probably not getting paid very well, and are probably struggling to survive. And so when there's a race to the bottom, when there's a lack of regulation, where there's an avoidance of rules and laws, there is a cost to that. That's not costless.
And on that note, I do want to be completely as fair as it goes with my own perspective, but when you talk to workers in the gig economy, what's the psychology on their part as far as participating in these things and not wondering why is it cheaper? And isn't there a bit of responsibility on the driver's part with Uber or DoorDash or Grubhub or Lyft or any of these other delivery services or rideshare services that they also bear a responsibility for participating in sort of pulling the plug on the cab industry, and then now are asking for compensation for kind of a disruption that they took part in?
Well, let me talk first about the psychology from what I know of the workers who are driving these businesses. So for one thing, these companies have painted this myth that, everyone loves this work. Well, let me rephrase that. A lot of people really do love this work because they love the flexibility it provides. They love being able to make cash at the times that they're able to work. They like not having set hours. They like not having a live boss right over their shoulder, although, of course, they do have a boss, and that boss is maybe an algorithm on an app. But the lie that these companies are trying to perpetuate is that having that flexibility means that you can't have the protections of the workplace, that you can't have those labor and employment laws protecting you. That is absolutely a lie. There is no reason that these companies cannot be classifying their workers as employees and still providing them with that flexibility. Plenty of employers in America today have realized that they're going to get the best workforce, or they're going to have their best pick of employees if they provide that flexibility. So the threat that these companies have held out that, hey, we have to keep everyone as an independent contractor or else you're not going to have that flexibility is just a threat. There's nothing incompatible with flexibility and employment. Now, going to your second question about don't the workers themselves have some responsibility for what happened to the cab industry, now my answer is no. It's the people who came up with these ideas for these companies and put them in place. They're the ones who disrupted. The people who came along and took a job there, they're trying to make ends meet. They're trying to make money to support themselves, to support their families. A lot of the drivers out there are former cab drivers. So I've represented cab drivers. A lot of them have realized they can't make it in the taxi industry anymore because the taxi industry is dying. So a lot of them went out and they bought their own vehicle so that they can drive for these companies, either one of these so-called rideshare companies or these food delivery companies. And basically what these companies are doing by having the drivers go out and purchase or lease their own vehicle is they are shifting the costs of running a business to the workers. So in other words, you can have a transportation company under this model that doesn't have to own any vehicles. You can have a delivery company that provides delivery services who doesn't even have to own any vehicles. So, for example, Amazon. We're representing Amazon drivers now, too, across the country. Amazon, which is one of the largest companies in the world and owned by the richest man in the world, has figured out a way to be a delivery service without actually owning any vehicles by having the workers bring their vehicles to work. And think about it. How many jobs can you think of, low-paying jobs, minimum wage jobs, or just above minimum wage jobs, where the worker has to bring a several $1,000 piece of equipment to work every day, fuel it, take care of it, maintain it? I mean, I think it's a little insane.
Well, I mean, there are jobs like that, and you're right, the minimum wage part of it. You might get paid $15 an hour for your labor, but you're also able to generally, in the past, at least in the last 80 years, be able to charge a fee for you bringing that equipment on top of your wages. So I would put that nuance into your comment there. And on the topic,
under California law, employers are required to reimburse their employees for any expenses that are necessary to do the job.
Right.
And that reimbursement has to be on top of whatever wages they're being paid. So the main claim that we have brought in our litigation against the gig economy for workers in California has been to obtain that reimbursement. And the way we measure the reimbursement, the simple way the courts let us measure it is by using the IRS mileage reimbursement rate. So think about that on top of whatever pay the workers have received, drivers have received for doing deliveries or doing rideshare. Our claim, the legal claim that we brought in court and in arbitration, is that they should be being paid back the amounts differed through the years, but 50-something cents per mile for the work they've done for these companies.
The reason I mentioned the last 80 years or so is because a lot of the labor regulations that you're working with in your lawsuits and what we've gotten used to since the Great Depression, since the end of the Great Depression, have really been, in a really ironic way, rolled back by people saying, look, this is an app. It's based in your phone. Our business is based in your phone. And so then somehow these companies are trying to get out of the labor regulations that exist in the physical locations where their workers are working. Can you talk about how that's being navigated by yourself and by the companies?
Yeah, sure. So this is the big issue, is that these companies are trying to claim that they're doing something new, that all of those old-fashioned employment protections that got put in place over decades, going back to the New Deal, are no longer relevant, no longer make sense, but they absolutely make sense. There is a reason why we as a society put in place decades ago basic protections for workers who are providing labor that make a company what it is. So it really galls me to hear anyone call for our changing these rules or tearing down these rules, because what we're supposed to be helping these multi-billion-dollar companies get even more rich off of the backs of workers who need these protections. The companies are trying to claim that the workers don't want to be employees. They want to be independent contractors. But again, it depends on what question you ask. If you ask, hey, do you want to have flexibility in your scheduling? Everyone's going to say yes. Do you want to have a boss breathing down your neck? Everyone's going to say no. But then when we talk to people, and we talk to our clients, and we talk to drivers who call us, and we ask, hey, would you like to have your expenses reimbursed for your vehicle, your gas, your insurance, your maintenance, your wear and tear? Everyone says, yeah, of course I do.
Where's your next move as far as the $20 billion settlement that Uber reached with this current case shortly before their IPO? And I'm wondering, was there a rush to get that settled before their IPO goes?
Well, I've been working on this case for a long time. I filed it in 2013. This is the original case that was filed against Uber for misclassifying workers as independent contractors. So this has been in the works for a long time. What happened was we had a class certified that consisted of almost all Uber drivers throughout California. That was several years ago. But then Uber took it up on appeal to the Ninth Circuit Court of Appeals. And because of some recent terrible decisions that have come out of the U.S. Supreme Court in the last several years, allowing companies to enforce arbitration clauses to prevent workers from banding together in court, our class got decertified on appeal, meaning that we could only then in court represent those drivers who either worked before Uber rolled out its arbitration clause, which was back in 2013, or those relatively few drivers who opted out of Uber's arbitration clause. So those are the drivers who are covered by the $20 million settlement. It's a little over 13,000 drivers. The vast majority of drivers got left out in the cold by the Ninth Circuit ruling, and unfortunately, if they want to try to recover anything, they have to go to individual arbitration. So we've been having our hands pretty full lately with handling the thousands of arbitrations that have emerged after that court ruling.
All right. Are you able to stick around for a little while? Because I have so many more questions for you, and I'm really enjoying this information session about the gig economy. I want to talk about your theory about the end of employment. Is it possible for you to stick around after the break?
I got a little more time. Yes, I can talk.
Sweet.
I can stick around for a bit.
Back here on Unquestionable, still talking with attorney Shannon Liss-Riordan, who is currently representing workers in various companies amongst the gig economy universe that, as she said, and I personally agree, is trying to convince us that getting a service through your phone is so new that none of the old rules of economy apply. So we're going to get back to that, and I'm going to expand the conversation here based on your video clip you sent me about the end of employment. And there's a presidential candidate, Andrew Yang, talking about the end of work due to automation, but you tend to maybe take a different look at what the end of employment would mean, correct?
Yeah, what I'm particularly concerned about is all of the employers out there who are trying to build a workforce where no one is actually an employee. No one has the protections of employees. None of our wage rights or labor protections would apply. And you're right that the gig economy has been trying to pass itself off as something new and making all those rules and regulations so old-fashioned. But the truth is there's nothing new. There's nothing new about this scam. Employers have been doing this for decades, and I've spent much of my 20-year legal career fighting against companies who have used lots of different kinds of labels to try to avoid all employment protections. I've represented cleaning workers. I've represented truck drivers. I've represented strippers. I've represented call center workers. The list goes on and on. The gig economy just has this new twist to it that the work is dispatched through a phone. But this is the same labor battle that we have been fighting for years.
And where does the case go now after the $20 million settlement that was rumored to be possibly $100 million a few years ago when it was in its beginning stages? There was criticism of your law firm and the other lawyers helping you. There was criticism of the fee structure, and you guys did cut your fee at that time. I believe 3 years ago, those stories broke. How did that end up affecting your case? What do you say to the criticism of the fee level for representing these workers?
Yeah, so several years ago when we had a class certified that consisted of most Uber drivers in California, I was able to negotiate a $100 million settlement, which would have been a landmark settlement, one of the largest employment settlements ever in California, if not in the country. So a lot of other lawyers jumped in on that because they were kind of mad that I did that, and they wanted a part of the fees, and our fee request was pretty typical of what is paid in these contingency cases. But when there was a threat that the court might not approve the settlement, I was pretty horrified, and I wanted to do everything I could to protect it for the workers. So I offered to cut the fee in half, and that still wasn't enough for the judge for kind of obscure reasons. He didn't approve that settlement, but then I went on to be proved right, because what happened was after that settlement wasn't approved, Uber proceeded with its appeal, and Uber succeeded at the Court of Appeals in getting the class decertified. So after that, we were no longer able to represent most Uber drivers in California. We were only able to represent those few Uber drivers, about 13,700 of them, to be close to exact, who weren't bound by an arbitration clause. And so for those drivers, we were recently able to pick up the pieces and obtain a smaller settlement, a $20 million settlement. It will be more for each of those drivers than they would have received under the proposal we reached several years ago. But the vast majority of drivers are left out in the cold because of the Court of Appeals, and that's what I was warning about several years ago when I explained explained why we had agreed to that. So now the drivers who don't have arbitration agreements can participate in this $20 million settlement. Anyone else who wants to be a part of this has to bring an individual arbitration. Unfortunately, most people are never going to do that because they're not going to find out that they can or that they should or how to go about doing that. So that's what happened there.
Now, when cases get settled, it's not as beneficial, often not as beneficial in the form of setting precedent for future cases because there's often clauses that conceal parts of the proceedings or basically there's not a verdict issued by a judge in some of the cases that are settled. It's not the same as a judge coming in and saying, this is my decision. How does that affect future cases for these, considering that it was a settlement?
Well, so whenever there's a settlement like this, there's always still the opportunity for more cases to go forward if the company is still engaging in the same behavior that it's been engaging in. So we have cases that are ongoing against many gig economy companies. And what happens in the courts is some cases settle, some cases power on. I've had cases that have gone on, and the cases that do go on can go on for a very long time. I have had cases that have gone on for more than 10 years. And there's always a balance. If a company is willing to pay a settlement, we've got lots and lots of clients who are frankly desperate to get a check because they're trying to support themselves, they're trying to put food on the table. So we have to look and see and consult with our clients and figure out when it's time to take a settlement that'll get cash in people's pockets now and which cases we can and should battle on. So I've got plenty of cases that we're battling on. So I just won a case last week, actually, that I have been fighting for 11 years. So that took a really, really long time. It was on behalf of cleaning workers, and it created a precedent in California that I'm hopeful is going to help workers in the gig economy, help workers throughout California get their employment rights under the law. The name of the case is Vasquez versus Jan Pro Cleaning. And so there are cases that make their way through the courts, and those are the precedents.
Also, I doubt you want to do this in Santa Cruz unless there's a ton of people that you got to listen to this show in Massachusetts, but there are strong indications that you're eyeing a run for Massachusetts Senate, primarying Ed Markey. And I was wondering if you wanted to comment on how that plays into the work that you're currently on.
Yeah, absolutely. I am considering a run for the U.S. Senate next year in the primary from Massachusetts. And the work that I've spent my career doing for the last 20 years is exactly what is driving me in that direction. I have spent 20 years in the trenches fighting for the rights of working people. And I've been doing everything I can to enforce the law for working people. And at this point, I think it's time. I want to use my skills and my experience to change the law. I think there's a lot of things that are going on that are affecting our society today, many of which stem from income inequality, which stems from these abuses that I've been spending my career fighting in the workplace. So I want to take this fight to Washington because I think working people need a voice in Washington, and I don't think their voice is being heard right now.
All right. Well, thanks again to attorney Shannon Liss-Riordan out of Massachusetts. A lot of cases involving New York and California because that's where all the money's coming from for these gig economies. But
And Massachusetts. We've got some good laws here in Massachusetts. We've done what we can to get these laws spread elsewhere, including in California. And I'd like to see some of these advances we've made be taken nationwide because there are critical fights at hand. And I think if we don't make a change soon, there is not going to be any employment as we know it in this country in the coming decades. So this is a critical fight.
All right. And she's not talking about loss of employment as in you get to go do what you want. They still want you to do work. Thank you so much, Shannon, for being on the show.
Thank you. Thank you for having me.
And what's the point? What's the point of all of this? The point for me is that I think it's exciting news, and I wanted to share it with people, all the stuff going on. There was an article I read that said Uber's IPO was the biggest failure in stock market history. I don't know exactly if I believe that, because the founders of Uber made a lot of money last Friday, but maybe they didn't make as much as they wanted. Maybe that's what that whole thing was about. And I really care about workers continuing to get paid. I work in an industry where there's a lot of, in the service industry, where there's a lot of wage theft. I don't personally suffer from it because I'm very adamant about policing it. But there's a lot of people in all of these services, delivery services, ride services, food service, strippers, all kinds of people that have their wages kind of disappear between the customer's hand and their pocket. And it's interesting. There's an article in New York Times that says, strike all you want, Uber's never going to pay you a living wage. That's an interesting one. And basically, they just say that Uber will treat any settlements, any lawsuits as the cost of doing business. And that goes back to something that I talk about all the time with the opiate-producing pharmaceutical companies, with Uber, with anyone that makes an unsafe toy that kills a bunch of people. This country has a tradition of not putting businesses out of business, as I spoke about with Shannon Liss-Riordan. We simply fine them an amount of money. Wells Fargo pays hundreds of millions of dollars, billions of dollars all the time as payments on past fines for violations of law. Purdue Pharma pays hundreds of millions of dollars all the time in fees for being caught lying about their prescriptions, lying about whether they were addictive, pushing them for causes that they probably weren't meant to be used for. And they get to treat that as the cost of doing business because the fines never touch the amount of money they made in profit. And if I can make $500,000 or $1 million breaking the law, and I know that the fee or the fine is going to be $50,000 or even $200,000, why wouldn't I do that? Especially if no one goes to jail. If I can make it a limited liability corporation or incorporate it with someone so that I'm not the named owner of the business and I can always skirt responsibility and just push it around in a circle between the people that work there, then no one goes to jail. And if only 10% of your profit goes towards paying for the damages that you cause to society, then why wouldn't people do that? And maybe we need to think about the fact that if you have a business that kills people and you know that you're killing people, or you know that you're going around labor rights regulations, and you know that, maybe you shouldn't be able to just pay 10% of your profits towards fixing the damage. I don't know. Maybe that's crazy. Why should anyone be punished for harm that they do to society? I'm probably wrong, but this system is continuing to go in the wrong direction. I was just talking with a fellow DJ here who's going to be up on Oiko next about Elizabeth Warren and how awesome those policies are to this DJ. And I was like, yeah, I read an article that said she probably won't be the nominee, but her policies might be. And I really hope that either one of those is true. Either she is the nominee, I'm okay with that. That'd be cool. Or that her policies are, because she was the architect of the Consumer Financial Protection Agency, and that agency has probably been one of the most demonized in the history of the United States over the last few years. And every time they try to enact anything that's going to help us as average people be protected from people that want to make billions of dollars without either paying us or without having proper safety mechanisms in whatever they're producing, it really becomes a problem. But DJ Gina of Oiko fame is in the studio right now. And actually, do you want to say hi and let people know what your show is going to be? Because I'm going to end Unquestionable here in about 30 seconds.
All right, awesome. So this week we're talking about a recently released report by a branch of the UN. Is one of the largest reports on the global health and biodiversity of our world, and it's kind of a bleak picture. So we're going to be talking about that in the next hour, and that's coming up at 1.
KZSE Santa Cruz, you're uplifting broadcasting throughout the afternoon of Monday, every Monday from noon to 2 p.m. Dr. Gina, I want to call her Dr. Gina because her show is about science, but no. DJ Gina gonna be on here helping to uplift you with the bleak picture of the environment after I made you smile about the bleak picture of labor. Gonna leave you here with a little bit of Do Make Say Think to bridge the gap. Thank you so much. Unquestionable. Be back next week. I'm gonna have Slug Support on to talk about what it's like to be a grief counselor in the University of California system.